Hello, everybody. Yesterday, the proposed decision of the administrative law judge became available, and there are some incredibly concerning things about this decision that I think are reflective of ongoing problems that we've been experiencing with our union leadership. A number of people have reached out to me and asked me if I could break down the decision, but first, the decision is pretty straightforward. It really is not complicated. So basically, there are 3 points that stand out to me that in general should be addressed. The first is that there were 18 individuals who were able to argue. The judge refers to them as respondents, and that is the correct legal terminology for them. So 18 respondents who were able to make the argument that the RIF as it applied to them was inappropriate, and the judge expressed that they cannot be issued a final notice. The second point revolves around the counselors. The way in which the school district RIF'd the counselors, the judge determined was inappropriate. It's inappropriate to classify them into 2 distinct classes, that there is no difference between the credentialing of the job that they do, and so the district has to reorganize the RIF in regard to who they send final notices to based on seniority, not based on classification. Pretty straightforward, pretty simple to understand. It's not going to be nice for the people who our union hasn't prepared for this kind of turmoil, but we'll get to that in a minute. I want to discuss what I think is the third and most significant point to the general membership, and that is the judge directly points out that the union did not argue with or take a position regarding the skipped categories. And so the judge in that situation is compelled to accept the fact that the skips are valid, or at least the category is valid, that the category of skip is a valid skip. And with the union not taking a position on this, the result was that it turned into everybody for themselves. And so educators had to argue against educators, noting that they were more qualified or that they were better positioned to do specific jobs. And so you had educator A arguing against educator B. It was everyone for themselves. Catfights against one another where personal feelings and hostility ruled the day. It's so upsetting to me because this is something that under no conditions should ever happen, but it did, and the union does not have a position on this, and people had to fend for themselves. So, what position did the union take? The position the union took is best identified in the email that they published to us a couple hours after the judge's proposed order became available, and they put it right there in bold. During this portion of the process, our legal counsel will not accommodate individual questions and concerns. This just makes absolutely no sense to me. As you all know, I'm a licensed attorney with over 25 years of legal experience, and we have a zealous duty of representation of our clients. Number one thing in regard to zealous representation of our clients is communication. Communication is the single most important thing. You have to be in touch with your clients. So when I read that, it's very, very disconcerting, and it just really makes me wonder if that is truly the attorney's position, if the attorneys understand that the union is expressing that they're not fielding any questions. So I want to tell you a personal story. There was a person who was so affected by this that they sought out my guidance, and my suggestion was, instead of asking a question of the attorney, which has been barred, you should contact the union and tell them you don't have a question. You have a comment and a statement. And nowhere did the union say they're not fielding comments and statements. And so maybe that'll be able to get you in touch with the attorney, because they had a very valid legal claim that they needed to express. So if my understanding is correct, the response that the person got was that the attorneys are not fielding questions or comments or statements. I just don't know that that's really the case, or if it's our union if this is true, then the union is blocking the membership from reaching their own attorneys, which is all part of zealous representation. And the main reason why so many of us are members of this union is that when circumstances arise that require us to have legal representation, which they do, as hundreds of people just experienced with the RIF, the union should not be standing in the way of us communicating with our attorneys. So this update is just incredibly intolerable. And why should the attorneys be the ones answering all of the questions? The attorneys certainly should be giving legal guidance and advice, but not every question requires legal guidance and advice. Some people just need emotional support, or some people need their hand held to understand things. And this is essential to understand. In that office, these people can answer questions. There's the president, the first vice president, second vice president, the person who is on full-time release. Why can't any of them answer questions? They have been there for 20 years. In fact, they've been through a RIF process before. Some of this should be basic for them. And in addition to this, there's a CTA staffer who are dues paid for to be there full time. Presumably, this person is well trained in the number one type of teacher layoff. So how are these people not willing to be holding live Zooms, taking questions, saying that's a question that needs to go to the attorneys, or we'll run that question by the attorneys, and just answering every question that they can? Remember, these people serve on all the committees. It's not acceptable for them to be claiming that, well, this is so complex, we need time to process and understand. Remember, these people are the bargaining team. You have your first vice president, the second vice president's chair of the bargaining team. You have the health benefits that they are on. These are the two most important committees. Both the first vice and second vice are on that committee. And the full-time release is now on the bargaining team, as well as the chair of the organizing committee. These people have assumed every significant role for themselves in our union in their process of making it their private club. You would think they would be the foremost experts on every single matter, especially those including RIFs. They should be eager to accept and field your questions. And if there is a particular legal question that they just aren't capable of answering due to not having the legal experience, then fine. Set that one aside. Put that one in a parking lot. Seriously. But enough is enough of that kind of nonsense. I want to make it clear. While I'm not in a position of any kind of authority or being able to make any arguments on people's behalf, I just want to make it clear. I do have a lot of personal experience. I certainly was involved in the last RIF process with many of these individuals. And so if you have any questions at all, or if you think there's anything I could do to be of help, please just reach out to me. But I'm not just an individual. There are hundreds of us. And from our group, we have MBAs. We have people who are incredibly experienced with our health benefits. People who've been through the RIF experience before. We'll get back to you, and we'll do the best we can. I would still encourage you to also demand that your union, you're paying like over $1,200 a year. You know, my bar dues are only $575, and that's because I joined a particular section this year to try to improve my knowledge about certain types of litigation. And I wonder about all of our top leadership. What affiliations do they have where they've tried to improve their knowledge and leadership abilities. Anybody ever even go to a Toastmasters to learn how to speak in public? Anyway, there's a lot to be done, a lot that needs to be processed still. The school board could conceivably decide to reject the proposed order, or they could choose to reject portions of it. Anyway, I think this will suffice for now. And I thank you for watching and encourage you to please share the video with anybody that you think would benefit from this type of information. So hang in there, and you're not on your own. Feel free to reach out. Thank you.